We're looking at a Supreme Court case today that presents this really severe economic paradox for Canada.
Right.
And the question is, why is a victory for the rule of law in Washington potentially so much worse for Ottawa than a defeat?
It's completely counterintuitive.
It is. I mean, this is one of the most consequential, yet least understood developments for North American trade in decades.
Yeah.
And it all hinges on, well, the incredible volatility of U.S. politics.
That's exactly it. And our deep dive today is going to focus entirely on that strange dynamic. We're going to dissect the central legal challenge that's before the Supreme Court right now.
Okay.
It's about the legitimacy of the U.S. president's power to impose these sweeping trade tariffs under a kind of arcane law called the International Emergency Economic Powers Act, or IEPA.
By EPA, right?
And for years, this authority, as stretched as it's been, has basically governed a huge part of U.S. trade policy. But, and this is crucial for Canada, the current system has these significant exemptions built in.
And those are what's at risk?
Those exemptions are now fundamentally at risk.
Okay, let's unpack this immediately, because the stakes for you, if you are a business operating anywhere across that border, are just enormous. This could reshape the whole legal basis for global trade barriers. So what is the core question that the Supreme Court is looking at?
Well,
Does the president actually have the authority constitutionally to use an emergency law like IEEPA for, long-term trade policy?
to really get the challenge, you have to look at the history of IEP itself. Congress passed this back in 1977,
Okay.
and it was designed for genuine acute national emergencies. Historically, it's a tool for a president during a crisis. Think freezing assets of a hostile nation or blocking terrorist financing.
Things like that.
Sanctions. Exactly. The whole point of the law was for it to be a surgical, temporary tool.
Yeah.
Something you only pull out in these really extraordinary circumstances that threaten national security. It was never, ever meant to be a primary way to set routine tariffs.
And yet, that is precisely how the Trump administration ended up using it. They declared a national emergency about threats to the U.S. economy, a very broad declaration, and then use that to justify tariffs on all sorts of goods from multiple countries.
China, Mexico, even Canada for a time.
Right. So this is where the legal fight begins. They used a tool designed for, say, global conflict and aimed it at commercial trade. That feels like a very intentional expansion of power.
It is. And the challengers, we're talking about various corporations and trade associations. They argue that this stretches the whole concept of an emergency far beyond what Congress ever intended. But more importantly, the challenge goes right to the very heart of the constitutional structure of the United States.
How so?
Article 1 of the Constitution gives Congress, and only Congress, the power to regulate commerce with foreign nations.
Okay.
So if a president can just declare an emergency and then unilaterally impose these huge economic regulations, well, they're effectively bypassing Congress's constitutional authority entirely.
So it's a separation of powers argument, that the executive branch is basically usurping the legislature's job under the guise of an emergency. This isn't just a trade spat, then.
No, not at all. It's a foundational constitutional dispute about where power actually lies. I mean, if the president can define any persistent economic issue, like a trade imbalance, as a national emergency,
Then the checks and balances just vanish.
they vanish. And that is the magnitude of the question the Supreme Court is weighing right now.
And while all these legal scholars are arguing about the limits of presidential power, you have Canada just across the border in this totally contradictory position. They're watching this purity test and realizing that if the Supreme Court rules for the Constitution, Canada might be the one who ends up paying the price.
And that is the paradox in a nutshell. Because right now, under the current IEPA tariff structure, Canada has a temporary but very critical safety net.
Okay.
This existing structure includes really significant exemptions for Canadian goods, which were formalized through the Canada-United States-Mexico Agreement, or COUSMA as it's called in Canada.
Let's just clarify what that protection really means. So when these tariffs were imposed, they were often aimed at, say, global strategic competitors.
Right.
But because Canada is a treaty partner under KUSM, they managed to get exemptions for certain goods or specific carve-outs in areas like steel and aluminum.
That's the key. Canadian businesses, particularly in manufacturing, auto parts, they've reached a kind of operational stability. They've been able to invest and plan their supply chains, assuming those KUSMA exemptions will hold. So the current structure, as legally flawed as it might be, is providing some functional stability for hundreds of billions of dollars in trade.
So if you're an official in Ottawa, you should be cheering for the Supreme Court to strike this down. But instead, you hear reports of this growing sense of dread. Why is a constitutional win seen as a potential disaster?
Because of the contingency planning. The assumption in D.C. isn't that if the INEEPA tariffs fall, all the tariffs just disappear.
No.
The assumption, based on very public statements, is that they will be replaced probably almost immediately with something much worse.
And that's where this gets incredibly serious for businesses on both sides of the border. It's not about them accepting defeat. It's about them rebuilding the tariff wall on a different and maybe even stronger legal foundation.
Senior Trump administration officials have been remarkably candid about this. You had, for instance, former Treasury Secretary Scott Bessent state publicly that if the IEEPA authority is struck down, they've already identified alternative legal authorities. He said they have the ability to, and I'm quoting here, recreate the exact tariff structure using alternative legal methods.
Wow. So the message is clear. The tariffs are staying one way or another.
The objective remains, regardless of the legal pathway.
So if they just rebuild the exact tariff structure, why should Canada be so worried?
Because the replacement authorities, they don't have the same built-in flexibility. They don't have the reciprocal exemptions that were negotiated into the current IEPA structure through CUSMA. So when this new framework emerges, built on a totally different legal foundation, there's absolutely no guarantee that Canada's exemptions will survive the transition.
Can you give us a sense of what these alternative legal methods are? What statute would they even pivot to?
The main ones they'd likely use are Section 232 of the Trade Expansion Act of 1962, and maybe Section 301 of the Trade Act of 1974.
Okay, Section 232.
Section 232 lets the president impose tariffs if the Commerce Secretary finds that imports threaten national security.
Right, we saw that with steel and aluminum.
Exactly. And while Canada got a temporary exemption then, its application is entirely discretionary. It's not mandated by any existing trade deals.
So if they use Section 232 again for a broad range of goods, there's no obligation to exempt Canada.
Zero. That's the critical difference. IEEPA was challenged on constitutional grounds, but its use often ran parallel to agreements like USMCA. If they pivot to a Section 232 national security finding, well, as one trade consultant, Eric Miller, bluntly warned, the new tariffs could end up being applied directly to Canada with far fewer political hurdles.
So they can just say national security is threatened, and who's an ally and who's not becomes a completely subjective judgment call.
It becomes an executive judgment, entirely.
And what about Section 301?
Section 301 is another really powerful unilateral tool. It's usually for addressing unfair trade practices like intellectual property theft, which is why it's been used so widely against China.
Okay.
Applying that to Canadian goods would be a fundamental diplomatic shift. It would frame Canada not as an ally, but as a country engaged in unfair practices. It's a very aggressive legal basis for tariffs.
So the core risk is that Canada's currently protected by a structure that's unstable, and the replacement is expected to be broader, more aggressive, and less accommodating.
Correct. And we also have to think about the chaos window.
The chaos window.
Yeah, if the court strikes down the IEPA tariffs, they don't just flip a switch to the new system overnight. There's going to be this unavoidable period of massive uncertainty.
And supply chains hate uncertainty.
They depend on predictability. If customs enforcement suddenly shifts, or if the legal status of goods crossing the border is unclear for a day, a week, trade effectively freezes.
The practical impact during that window would be profound. I mean, think about just-in-time inventory, especially in the auto sector. Parts cross that border 5, 6, 7 times before cars even finished. A week of tariffs being in flux could stall investment, stop parts from moving, and cause inflation to spike in certain sectors.
And that risk of disruption is what is generating this sense of dread in Ottawa. They know that by the time a replacement regime emerges, it'll be designed to survive legal challenges and will almost certainly be less lenient. They're just spectators to a process that can throw their entire supply chain into disarray.
Let's just anchor this in the sheer scale of the relationship for a moment. We're talking about one of the largest bilateral trading relationships in the world. Over $700 billion a year in goods and services.
That's hundreds of billions. And it's not just abstract numbers. Millions of jobs on both sides of that border depend on that trade moving smoothly.
Yeah.
When we talk about disruption, we're talking about the factory worker in Windsor who needs parts from Michigan.
Or the farmer in Saskatchewan selling grain south.
Exactly. Their livelihoods depend on this commerce being stable.
And this puts the Canadian government in just an impossibly difficult position. They're watching a legal drama in Washington that's going to determine their economic future, but they're completely unable to influence it. They can't argue before the justices.
All they can do is wait. It is a really strange form of diplomatic helplessness for a G7 nation. The Canadian government is forced to hold, like, two conversations at once.
How so?
Well, one conversation about preserving the exemptions they have now under IEPA, and a parallel one about seeking hypothetical future exemptions under a replacement structure, like a Section 232 regime that doesn't even technically exist yet.
How do you even negotiate for a shield against a weapon that hasn't been forged? That just seems completely futile.
It is, because the political incentives in Washington have fundamentally changed. For decades, you had this bipartisan consensus in favor of free trade.
Right.
That consensus has completely collapsed. The political incentives now point overwhelmingly toward economic nationalism, protectionism, and using aggressive tools like tariffs.
Which means Canada just becomes collateral damage in an American political war that has almost nothing to do with Canadian trade practices.
Exactly. When U.S. politicians talk about getting tough on trade, they might be thinking about China, but Canada gets swept up in the policy that follows.
It's the weaponization of trade policy.
It is. And if the Supreme Court actually validates the IEPA tariffs, it sets a precedent that emergency powers can be used for routine trade policy. It gives future presidents a clear roadmap for unilateral action.
But if they strike them down, as we've said, the administration pivots to those more aggressive tools like Section 232. And that path sets a precedent where trade policy is just used as a blunt, weaponized instrument, which undermines all the stability that businesses need.
The message to the entire world is clear. Your access to the American market, it doesn't matter how friendly you are, is subject to sudden, profound disruption based entirely on U.S. domestic politics.
So what does all of this mean for you, the listener? It means Canada is trapped between two completely unappealing scenarios. Caught in a vice where neither outcome really offers any clear relief.
And that's the core tension to remember. Constitutional principles, however compelling they are in the abstract, they don't necessarily translate into practical economic benefit. A legal victory that results in broader, more aggressive tariffs. Well, that's no victory at all for the Canadian worker who loses their job because of the chaos that follows.
This whole situation makes it crystal clear that access to the American market for Canada, which is absolutely critical to its prosperity, depends almost entirely on the whims of whoever is in the Oval Office and the unpredictable volatility of U.S. politics. The stability for millions of jobs relies on a structure that Ottawa cannot control. So our final thought for you to mull over is this. When a G7 ally's poor economic security is held hostage to internal constitutional debates it can't even participate in, what structural changes should that country be considering to regain some sovereignty over its own economic future?